Good day to you and welcome to another Paddocks Club video tutorial. Today I'd like to address a topic that on various occasions I've dealt with as a consulting matter, namely whether schemes can restrict short-term letting. Many people own property in sectional title schemes for investment purposes and they let their units out to tenants for rental income. With accommodation reservation websites such as Booking.com and Airbnb, it's never been easier to find short-term tenants in schemes that are located in holiday destination hotspots, city centre condominiums, and seaside apartments. The landlord can collect a higher rental fee per night on a short-term basis compared to longer lease agreements. Many bodies corporate complain that the short-term tenants can be troublemakers who breach the conduct rules, jeopardize the reputation, security, and property value of the scheme. The trustees are tasked with the duty to control, manage, and administer the common property and to do all things reasonably necessary for the enforcement of the rules of the scheme. However, the trustees should not unreasonably restrict or regulate the manner in which owners use their section, and should not limit the proprietary rights of investment owners who could be adversely affected where scheme rules restrict short-term letting. Such a restriction would limit the rental pool of tenants that the owner could let the unit to and make it difficult for the owners to obtain the maximum rental return for their section. The concept of short-term letting is not defined in the Sectional Titles Act or the Sectional Title Schemes Management or the prescribed management rules or the prescribed conduct rules. Various provisions do refer to and bind owners and occupiers. Occupiers is also not a defined term, but it would include short-term tenants. Ultimately, Prescribed Management Rule 3, Sub-Rule 2 states that a member must make all reasonable steps to ensure compliance with the conduct rules by any tenant or other occupant of any section or exclusive use area, including members, employees, tenants, guests, visitors, and family members. It's the duty of the owner to ensure that his or her tenants and other occupiers comply with the rules. This is a partial restatement of Section 10, subsection 4 of the Sectional Title Schemes Management Act, which provides that a scheme's rules bind the body corporate and the owners of the sections and any person occupying a section. Prescribed Conduct Rule 7, Sub-Rule 4 states that the owner or occupier of a section is obliged to comply with the conduct rules, notwithstanding any provision to the contrary contained in any lease or other grant of rights of occupancy. The Sectional Title Schemes Management Act gives the owner certain duties when letting their unit. For example, Section 13, subsection 1, subsection F imposes an obligation on the owner of a unit to notify the body corporate when they let out their units. Furthermore, the Rental Housing Act states that a copy of the scheme's conduct rules must be attached to an annexure of the lease. Furthermore, the landlord must ensure that the tenant receives a set of these rules. A conduct rule could be adopted that states that owners are entitled to continue letting their units on a short-term basis, but subject to certain conditions. For example, the owner must keep proper and accurate records of the full identities, addresses, contact details of all the tenants leasing their units. Also, the owner must ensure that a copy of the scheme's conduct rules are made available to each and every tenant that they let their unit to. Finally, the owner must ensure that each tenant sign an undertaking to comply with the scheme's conduct rules. The scheme rules should address the specific actions or behavior of the short-term tenants, rather than to target the investment owners with blanket bans or overly restrictive rules. If the only problem the trustees see in this situation is a threat to scheme security, I suggest that they motivate making a new conduct rule that addresses access control and security. The body corporate should identify the undesirable activities that result from short-term letting and establish whether this high turnover occupancy process unreasonably interferes with the use and enjoyment of common property or other sections by owners or occupiers, and whether the activity causes a nuisance. In conclusion, if there is consistent, persistent, and serious nuisance due to the holiday letting, the body corporate should adopt a penalty rule. The trustees can then fine and otherwise act against an owner on account of the actions of his or her short-term tenant, when they act in a manner that is in breach of the rules. Thank you for joining me. If you have any comments or queries, please post them on the discussion forum.